deal with those at a later time. I will also advise the committee that we will not be running 5063. As of right now, we will not be running 5617, which is not on the revised agenda at this point. And I will also state that for 5305 and 5344, we're going to move those to the foot of the bills. We do intend to run those. So,
Hey, Joe, where's Joe? She's first up.
Joe's right there.
oh, there she is. Here's counsel. We're going to, yes, ask the clerk to call the roll to establish the presence of a quorum.
Thank you, Mr. Chairman. Mr. Kelly.
Here.
Mr. Akers.
Here.
Mr. Fluharty. Mr. Foster.
Here.
Mr. Garcia. Mr. Hanson.
Here.
Mr. Heckard. Mr. Hillenbrand. Mrs. Kimball. Mr. Kirby.
Here.
Mr. Kump.
Here.
Mr. Mallow. Mr. Marple.
Here.
Mr. Martin.
Here.
Mr. Nestor. Mr. Phillips. Mr. Pritt. Mr. Ridenhour.
Here.
Mr. Shamblin. Mr. Steele. Mr. Ward.
Here.
Ms. Warner. Mr. Westfall. Mr. Zeteslow. And Mr. Chairman.
Present.
Okay.
We do have a quorum, so we will now start with the first bill today, 5373. Council, when you are ready.
Thank you, Mr. Chairman. House Bill 5373, you'll note that the short title does need amended. This bill is intended to address appointments to vacant elected offices, political offices. It adds a requirement that all individuals who are appointed to fill those vacancies must be affiliated with the political party of the individual who vacated the office at least 60 days prior to their appointment to fill that vacancy. And that's a summary of the bill.
All right, questions of council? Any questions of council? If not, does any member seek leave to call a technical witness regarding this bill? If not, are there amendments? There will be an amendment forthcoming. The committee will stand at ease. The delegate from the 100th seeks to amend the bill, page 4, section A, line 12, change 60 days to 2 years. Gentlemen seek leave to reform his amendment, or explain his amendment. I'm sorry.
No, I don't need to explain it. It's pretty self-explanatory, and you did a great job doing that. And I'm not going to reform it at this time.
Thank you. Is there are there questions of council regarding the amendment? Gentleman from the 20th.
Just, well, probably the lead sponsor.
Questions of the lead sponsor. Does the gentleman yield?
Yes, sir.
Gentleman yields.
Just, my question is, the rationale by only changing one changing the legislature and not the section on Congress or the section on other vacancies.
Are you referring to page 5?
Yeah, page 5 and page 4 at the top of the page.
Because I didn't flip to that page, that's the explanation. So, request to reform my amendment, Mr. Chairman.
See, I had a feeling. Sir.
Page 1, 2.
All right, gentlemen's reform amendment. Correct me if I'm wrong, both places of the new language on page 4 and the new language on page 5 seeks to amend the 60 days to say 2 years, is that correct?
Correct, it'd be page 1, line 15.
Oh, I'm not correct.
Yes.
So there's 4 go ahead.
I was trying to emulate my delegate friend across the table from me. Page 4, line 24, page 4, line 12, and page 5, line 31, and change that from 60 days to 2 years.
All right. That is the gentleman's reformed amendment. Are there questions of council? Gentleman from the 16th.
No, the sponsor of the amendment yield.
Gentleman yields.
Yes.
Yes, I like the idea of this bill. I think 6 months, or what the original language was, way too short. I think 2 years might be too long, for different reasons, just my thoughts. Would the gentleman be any suggestion to revising it to 1 year?
I would be interested in that. I'm not sure that I would want to do
Okay.
that. The rationale is that parties need to understand that the individual that they are proposing for a position should be an individual who is reflective of the values and the issues that that party is trying to see implemented within state government. And 60 days is certainly too short.
Too short.
I think 6 months is frankly too short, because what you end up with at that point are political actors and not really those individuals who are reflective of that institution. I frankly think that 1 year is probably much more reflective of a political actor than 2 years. What you're looking at 2 years is somebody who's actually committed themselves to understanding what is the value, what the values are within that party and the constituents of that party are. So you've got a much better understanding at that point. 1 year, as I said, I think is too focused on individuals who are making those types of changes that we've seen by both parties. For political reasons, they're individuals who are the types of people that most of the electorate do not like, which are professional politicians. What we need are people, I think, and this is my belief, and that's why I've submitted this amendment. What we need are people who are reflective of what that party believes and what those individuals within that party believe, what the party actually purports to be about.
Okay, thank you, sir.
Thank you, sir.
All right, other questions of the sponsor or council? Gentleman from the 2nd, followed by the gentleman from the 79th.
Council, do we have anything in the books about people, timeframes for changing parties when you run for office?
No, you're fine. Yes, when you run for office, you have to be affiliated with the political party you're filing under for 60 days.
For 60 days.
Yes.
So if we were to pass this amendment, you have to have 2 years before you're able to be appointed, but 60 days if you're going to run for office.
That would be correct.
Okay. I was curious.
Gentleman from the 79th.
Thank you, Mr. Chair. Following up on that question, what if you're no party and you want to run for a partisan office? Does that 60 days still apply?
Under current code, no. I don't believe so.
Yeah, I didn't think so either. But this bill is just for appointments, is that right?
The committee substitute is just for appointments. Yes, that's
Committee
correct.
substitute, okay. Do you know how many people or what percentage of registered voters in the state roughly are no party?
I do not.
Well, it's about 25% as a rough number of registered voters. So if somebody was registered in the state of West Virginia as no party, how would this how would this amendment impact them?
Well, my understanding from the language of Article of 310 throughout these different sections already is that if you don't have a party affiliation, you would not be eligible to be appointed to fill a vacancy created by somebody who has a party affiliation. It's already required that for the governor to appoint an individual to fill a vacancy of a political office, they have to take it from the list or from the general group of people who have the same party affiliation.
Okay, yeah, that makes sense. But could you walk us through, without this amendment, and Bill, if somebody is no party, and let's say a Democrat resigns, so that the local Democratic Executive Committee needs to put together a list of 3 Democrats, right, to submit to the governor. Let's say they're interested in somebody who's an registered independent or no party. Would there be any method for that person to be recommended to the governor by the executive committee right now? Could they switch their party immediately to Democratic Party and get on that list?
Under current law, yes.
Okay.
Yes.
Okay. So basically, this amendment would cut down on the pool of people who could potentially serve in government because it kind of removes 25% of the registered voters from even being considered.
I think that's a fair assessment.
Okay. Thank you. Thank you, Mr. Chair.
I will advise the committee, I do have a competing amendment. The competing amendment simply seeks to change the 60 days to 1 year throughout the committee substitute. So we do have that. We'll take up one, then the other if the first one fails. You may continue. Gentleman from 79th?
I'm done, thank you.
All right, thank you. Other questions, council? Gentleman from 76?
A question of the sponsor.
Does the gentleman yield?
Yes.
The gentleman yields.
So, right now, we've got probably a third or more of the people of West Virginia are independents versus switching from one political party to another. And in listening to you speak, I think that seems to be the bigger part, but I could be wrong, as far as somebody trying to switch for political gain, right? Versus just being an independent voter, non-affiliated, and then becoming interested at some point. I mean, do you have any concerns about that with the 2-year time period, especially now that here in 2026, the Republican Party is looking to close the primary and trying to recruit good people, because it's hard to find good people?
Well, as I articulated earlier, what the individuals that the party should be trying to select are those individuals that are reflective of the values and the issues that party believes are key issues that party should be focused on. If an independent wants to seek political office, then he or she should be looking at either becoming a part of that party so that they can in fact reflect those values, or well, I really think they should be trying to become a part of that party so that they can understand what they want to do and how they can do that within the party system. Otherwise, frankly, we should be looking at whether or not there should be any party affiliation with appointments. And I would not favor that. I think that, and I would think that your party would also want a replacement for a vacancy to be from your own party, not from an independent who has decided within 60 days prior to, or even a few months prior to join your party so that he or she can be appointed to a position that your party has won in an election.
Okay. Thank you, sir.
No
Thank you, Mr.
problem.
Other questions of council or the sponsor? Gentleman from the 79th?
Chair, I had a question for the sponsor.
The gentleman yields.
Certainly.
I want to follow up on that back and forth you had with the gentleman from the 76th. Would you agree that there's already a gatekeeper to fill a vacancy, in the sense that there's already a partisan entity, like the executive committee for that party, that puts together the list of people to nominate?
Would I agree that that's the case?
Yeah.
There is, but that doesn't necessarily mean that gatekeeper role functions particularly well. I've seen that in my own county, where we've had an appointment for a commission seat where there were questions about the affiliation of a couple of the individuals who were up for appointment, and I won't go any further than that for reasons of my county politics.
And the reason why I want to ask you to yield is because I think this is a legitimate policy question. Like, I feel like the Mon County Democratic Executive Committee, they're all Democrats because they're on the Democratic Executive Committee, and if there's a vacancy for them to fill, I'm not sure that it's up to us why would it be up to us to tell them that you could only fill that with someone who's been a Democrat for 2 years, when there's so many independents who have registered as no party for a multitude of reasons? They could just be fed up with politics, and it's an act of rebellion to basically say, I'm not going to affiliate with either party. But there's lots of people that are no party that, if you really asked them, they're going to vote Republican almost all the time, or they're going to vote Democratic almost all the time. So what's the compelling policy issue here to provide fewer choices to a local
But
partisan.
at that point, I would repose the question back to you, should there be any time limit whatsoever? Should an individual be able to switch within 24 hours prior to being appointed?
And I think there's a distinction in code between somebody who's no party registering with one of the parties versus somebody switching parties from R to D or D to R, and I think that would be appropriate.
Well, again, I would go back to what I had said originally. I think it's incumbent upon the party to, or the individuals who are seeking to be in a political office to be reflective of those values. I think it's a function of the executive committees of those parties to try and do the appropriate selection, but sometimes they may not be able to determine whether or not an individual is in fact reflective of those values. They may not do the research necessary. So I do think it's still a good idea for us as a state legislature for these positions specifically to try and ensure that those individuals are reflecting the party of values and issues.
Thank you, Mr. Chair.
All right, other questions of council or sponsor? Chair has a question of council. So council, this has nothing to do with any other requirements, it's just a requirement of a time period for party affiliation, correct?
That's correct.
And so that could even mean if a person lived out of state a year ago, and then they were a member of the political party they needed to be, and they moved in. If they met all the other requirements, then it doesn't matter where they live, correct? As far as this party affiliation term.
Yes, they do have to be otherwise legally qualified, and
Right.
I'm not an expert on what all of those are, but with respect to what we're amending, yes, only addressing the party affiliation.
Okay. All right, other questions of council? General Lady from 71st.
Thank you, Mr. Chair. Thank you, council. This just occurred to me with this discussion. Do you have to be a member of a political party to hold office?
To hold office generally? No.
So what happens in the instance of a vacancy of a person that was unaffiliated?
I'm not sure that scenario is contemplated by the code sections.
So are we by putting this into code, are we eliminating the possibility, for anybody else to hold office that would be, I don't even know the right question to ask.
Yeah, I understand what you're getting at. I don't think so, because even as the code already stands, the appointee to fill the vacancy has to be affiliated with the same political party as the individual who vacates the office.
So if that person were unaffiliated, then that would open it all up. And so they would have to be unaffiliated for 2 years?
I guess so. I don't know that I have a good answer to your question, Delegate. I'm sorry.
Thank you.
Gentleman from the 100th.
Question of council. Following on the my friendly delegates, which number? 71st. It would seem to me that if you had an independent who resigns from office, then the governor would have then the authority to pick any individual, whether or not affiliated with the party or not, independent, any political party, because it doesn't, an independent doesn't specify any kind of political party. So you obviously wouldn't have an independent party to select, potential appointees. Am I reading that wrong?
I don't know, because, I mean, it does specify that the governor shall appoint a person of the same political party. So I don't know that you could read same political party in the context of no affiliation to mean anyone affiliated with any party. I mean, like, no affiliation is different from affiliated with all, if that makes sense. Maybe it doesn't.
I'm not sure that I would agree, but, okay, thank you. Thank you, Mr. Chairman.
Another question, gentleman from the 94th.
Appropriate time, I'd like to request testimony by a representative from the Secretary of State.
Certainly at the appropriate time. Other questions, count gentleman from the 20th.
The inquiry of the chair while we're calling witnesses, as much as I enjoy the discussion we're having, are we talking about the amendments right now, or are we talking about general political appointments?
Points well taken. Let's make sure that we're talking about the amendment, whether to change 60 days from 2 years. Gentleman from the 94th, do you have a witness, Mr. Kersey?
Yes.
Mr. Kersey, would you be willing to take the witness stand?
Well, I get
Go ahead and
I do have my general counsel here.
That would be better.
attorneys you're both attorneys. Either one, it's your choice, Mr. Kersey. You can introduce yourself.
Good morning. I'm Deke Kersey, Chief of Staff for the Secretary of State.
You swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Gentleman from the 94th.
Thank you. As regarding this amendment, regarding the time frame, the question was asked, what about somebody that was appointed that from somebody to replace nobody that had a political affiliation? How would that affect, if a person had no political affiliation, how would the appointment be handled?
So a person that doesn't have a political affiliation is not a member of the political party.
Exactly.
And so the code here has a gap. Historically, and we inherited this interpretation from various administrations, historically the case has been if there's an independent in any party or in any position who vacates the seat, that seat's to be filled by someone similarly affiliated. That's the logic in code, that you're similarly affiliated as a Republican vacating, then a Republican gets appointed. Same deal if you're an independent. It's not been litigated and it's not been opined by the Attorney General, but that's been our guidance to counties. We have a situation right now in a county where this may be the case. And that's been our guidance consistent with past practices, that you would appoint that vacated seat by an independent with an independent or a voter who's affiliated as no party affiliation, or a minor party like Purple People Party. That doesn't happen, but it's usually someone with the same affiliation, whether it's a major party, minor party, or, quote, independent.
Thank you. That was my understanding also.
Other questions, Mr. Kersey? Gentleman from the 79th, followed by the gentleman from the 65th.
Thank you, Mr. Chair. Who would propose the names to the governor in that case?
Point of order, again, we're still not talking about the amendments at all.
Points well taken. Points well taken. 2 years or 60 days, that's what's before us. 1 year or 60, 1 year or 60 days. Other questions, Mr. Kersey? Thank you, Mr. Kersey. All right, any further questions of council? Does any other member seek leave to call a technical witness? Are there additional amendments? If If not, gentlemen from the 8th to move the committee substitute as amended. Oh, I stepped out. Committee will be at ease. All right, that was discussion on the amendment to change the 60 days to 2 years. As stated, we do have a competing amendment that would seek to change that to 1 year, so we will vote on the delegate from the 100th amendment seeking to change it to 2 years first. If his amendment carries, that will render the second amendment moot. If his amendment does not carry, then we will vote on the second amendment. So, all in favor of the gentleman from the 100th amendment? Discussion. Thank you. Gentleman from the 20th, followed by gentleman from the 2nd.
Yeah, and I just want to say, excuse me, I'm much more in favor of the gentleman from the 100th amendment because you got to realize 2 years, I mean, if it's 1 year or even the 60 days that are original in the bill, I mean, neither of those, they probably haven't even got a chance to vote in an election, haven't even got a chance to make an opinion of how they feel about candidates. They haven't got to vote on issues in that party, most likely. But the 2-year mark guarantees that they've at least been through an election cycle where they could actually make decisions and formulate opinions of how they feel about that party. So I think that's an important distinction to make, that they've actually been affiliated with the party for long enough to actually vote in that party. So I would urge adoption of the gentleman from the 100th.
Gentleman from the 2nd.
Chairman, I'm here to speak against this amendment. And why is because of my experience in this body. I don't know that 60 days is a long enough time for somebody who is going to be appointed. But I certainly have watched people switch parties in less than 24 hours while I've been in office. And they acted as I would have hoped they would act every time that any issues came up. And we were okay with that. It was acceptable. And it's still acceptable, frankly. But, you know, I think we're if we do this for an appointment and we have 60 days to switch parties to run in an election, there seems to be a big difference there. I don't know that 60 days, we could make it longer than 60 days, but 2 years is a bit much to me based on what we accept for people to vote in this body. So that's my 2 cents, and I am not in favor of the amendment for that reason.
Gentleman from the 16th, followed by gentleman from the 79th.
Thank you, Mr. Chair. I'm one of the sponsors of this bill, and to me, the 60 days was too short. I think 2 years is too long. I came in 2012, and since then, there's been a lot of people switch party affiliations. We've got a lot of independent voters in West Virginia, and some of those are slowly switching one direction or the other. I think with a year's time is enough time to know what direction you're going. I think 2 years is just a little too long and stuff for these appointments, so I oppose the delegates from the 100th.
Gentleman from 79th.
Chair. I'll be efficient and speak against both amendments at the same time. There's a couple scenarios here that cause concern to me. One is a scenario that was brought up earlier about a person who moves to the state of West Virginia and registers as a Democrat or a Republican. If that 2-year or 1-year time frame is amended into the bill, that means that that person would not be able to run for a partisan office for 2 years or 1 year. even if they've been a good Democrat or a good Republican for that period of time. That just doesn't seem right to me. But the other thing I don't like about the amendments is that it has a significant impact on our significant impact on our voters that are no party. And there's hundreds of thousands of those voters in West Virginia. They become no party for many different reasons. Often they're just mad at the system for good reason. They're mad at both parties. But that being said, there's a lot of people who are no party who follow politics closely, follow what we do as a legislature closely, who vote in every election, including primaries. I don't think it's accurate to draw a conclusion that no party voters are not engaged in the political system, knowledgeable about it, and qualified to be appointed to one of these positions. And it's a local control issue. If you're a Republican, if the Republican Party wants to impose a 2-year limit on Republican candidates, you have the power to do that because you have the local Republican Executive Committee members who can choose not to forward a name to the governor unless they've been a Republican for 2 years. That is totally something that you can do. But in order to put that in state code and impose that on all the parties is overreach. It overrides local control, and I think that's bad policy, so that's why I'm against both those amendments.
Gentleman from the 44th.
I would urge adoption of the amendment that expands it to 1 year. I think 2 years is a bit excessive. I would just remind the committee that two of the most most popular political candidates in West Virginia are former Democrats, President Trump and Governor Justice. And if you would have extended out as much as some of us would have liked to, it would have barred them from ever seeking office through the Republican Party. And I think the Republican Party as a whole would agree they've done a pretty good job. And so I would urge adoption of the 1-year amendment.
Other points of discussion? Gentleman from the 59th.
Thank you, Mr. Chairman. I think good legislating is sometimes about finding the right balance. I think 60 days, as has been previously said, is too short. I also think 2 years is a bit excessive. That's the length of an entire House term. And I don't think that legislation should be based on what 1 or 2 or 3 people may have done in recent times relating to party affiliation. I think we need to strike a balance on this issue. And I think that a 1-year time frame is a reasonable compromise, a reasonable balance, and we can align that with other sections of code fairly easily as well. So I urge rejection of this current amendment.
Gentleman from the 65th.
Thank you, Mr. Chairman. I'd like to echo the arguments made by the delegate from the 20th and in support of the 2 years. I think if you go to 2 years, then that assures that person has had the time to at least vote one time as that affiliation. I like the 2 years, and I hope we can get the 2 years. Thank you, Mr. Chairman.
Gentleman from the 8th.
Thank you, Mr. Chairman. Just a point of clarification. If we want the 1 year rather than the 2 year, then we vote against the gentleman from the 100th amendment as it is right now?
Correct.
Thank you.
Correct. Other points of discussion? If not, all in favor of the gentleman's? You're correct. You're correct. Sorry.
I believe it's incumbent upon this body to set the conditions for which elections are held. That's why I think this is an important bill. I think it's a great idea for us to set those types of conditions wherein we're requiring those individuals who are going to be appointed to reflect what that district or the state has selected in terms of the individual who is occupying the seat. I think it's best if the people who have nominated a political representative who is then elected, that the people who have been in that primary process and have voted for an individual, that they have faith that the individual that will replace the departing individual is in fact reflective of the values and the issues that they voted for in that primary election and then voted for in the general election. So that's why I think it's incumbent upon us to have individuals who reflect those values. And I believe that 2 years is the appropriate time frame that we should be looking at, in part because of what the gentleman from the 20th stated regarding the vote in at least one election cycle as part of that political party. So that's my recommendation. I recommend approval. Thank you.
The gentleman from the 100th has closed debate on his proposed amendment to change the 60 days to 2 years. All in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed, no? No. The noes appear to have it. Division has been called. If you are in favor of the gentleman's amendment, signify by raising one hand. If you are opposed to the gentleman's amendment, signify by raising one hand. On that vote, there were 4 yeas, 18 nays. The amendment is rejected. Ladies and gentlemen, that will take us to the gentleman from the 16th proposed amendment to change the 60 days to 1 year throughout. Is there discussion? If not, all in favor of the gentleman's proposed amendment signify by saying aye. Aye. Opposed, no? No. The ayes appear to have it. The ayes do have it. The gentleman's amendment is adopted. I have one other amendment before me from the gentleman from the 76th, and I will ask him to read and explain his amendment. Thank you.
Thank you, Mr. Chairman. So my amendment reads as follows. Amending the bill on page 1, section 3-10-3, line 7, after the word time, by striking the vacancy occurred and inserting in lieu thereof of the previous election for that office. Then on page 3, 3-10-4, line 16, after the word time, by striking the vacancy occurred and inserting in lieu thereof of the previous election for that office. On page 4, 3-10-5, line 4, after the word time, by striking the vacancy occurred and inserting in lieu thereof of the previous election for that office. And on page 5, 3-10-8, line 30, after the word party, by striking the words as the office holder vacating the office and inserting as follows, with which the person holding the office immediately preceding the vacancy was affiliated at the time of the previous election for that office. And in way of explanation, we're talking about switching parties to be appointed, but a bigger problem that we have had since a Supreme Court case in 2015 is that you can have someone switching parties after they've been elected, and then the governor or whomever would appoint somebody from the party to which they switched, which completely takes away the voice of the people who voted for that office holder, who voted for a Democrat. So I hope in this situation, gentlemen from the 100th talked about 2 years, and we've heard now a year to instill what it is or to be that person of the party. But when the people have elected somebody to come here from a certain political party and they switch for whatever reason, but in many cases to continue to be elected or for their own sake and not for the people, this would make sure that that does not happen and would reverse the Supreme Court's decision based on the language that was in the code at that time. And for that reason, I would urge passage.
Questions of council regarding the gentleman's
And the right to
amendment?
close, sorry, sir.
Questions of council?
Point of order, is this amendment germane to the
the bill?
I believe it is because it's dealing with the code section that is wide open, and I think he is talking about the appointment process, which is the purpose of the one-year language now, and he is just amending along with that. So yes, I would believe the gentleman's amendment is germane. Questions of council? Questions of council? Does any member seek leave to call or ask questions of the sponsor? Gentleman from the 100th.
Could you go through your explanation again? I was intrigued by it. I'm trying to follow it, and, you know, you're very articulate, but sometimes it is a little difficult to follow some of the more complex issues.
No, and I was speaking pretty quickly, too.
Yep.
No, I appreciate the gentleman. So there are 4 different sections that relate to different offices which are appointed, some by the governor, some by, I think, local boards or local county commissions. So the language in each of these currently states that the appointment will be, let me see where I can find it, the first one, for example, because the language is very similar. That for example, in 3-3 or 3-10-3, I think it's on, starting on line 11, but the governor shall appoint within 5 days thereafter a legally qualified person of the same political party with which the person holding the office immediately preceding the vacancy was affiliated at the time the vacancy occurred. And so what has historically happened, and this happened for the first time in 2014 after the election where Republicans gained the majority, but it was 17-17. And there was a senator at that time, who's a good person, who switched parties from Democrat to Republican and gave the Republicans an 18-16 majority. So at that time, that language was not there. And it actually was cut off at the point where it said holding the office immediately preceding the vacancy was affiliated, and there was a period at that point. So this has been changed based on the court's ruling in that matter. But it allowed him to be elected as a Democrat and then to switch parties, and the person who later was appointed in his spot was appointed as a Republican. And that
after, if I can, after he left office.
Yeah, that's correct. So he
resigned from office.
So for example, he switched parties. It was 18-16, right? And then the next year, I believe, or maybe I think it was the next year, he resigned. And so at that point in time, there were actually 2 lists that were provided from executive committees in his county, from the Democratic Party and the Republican Party, and the governor actually selected somebody from the Democratic Party with the idea that it really should be from the party where the people elected somebody, which I think really goes towards your argument on the last amendments that we were talking about. So that's what this would do. In the first one, it's state officials, justices, judges, and magistrates are non-affiliated, but then it would also proceed to vacancies in the state legislature with the exact same language there. And then, what's the other one? U.S. Congress. And then finally, vacancies in the Office of Prosecuting Attorney, Sheriff, Assessor, and Surveyor, which will be appointed by the local county commissions. And again, you know, right now, politics may be going one direction. I think this is fair for the people because it may not always be that way. So.
Understand. Thank you. Mr. Chairman, at the appropriate time, I'd like to call Representative of the Secretary of State's office.
All right, appropriate time. Before that, are there questions of council? Questions of council? It seems to be the appropriate time for the reappearance of the Secretary of State's office. Mr. Kersey, thank you for returning. Gentleman from the 100.
I don't know if you heard the discussion and the amendment. given the Supreme Court's decision, what would the Secretary of State's office perspective be on this change and whether or not it would be constitutional?
It would be helpful for a Reader's Digest version of the discussion.
Gentleman from 76, would you please re-explain your proposed amendment?
Absolutely. So, thank you, Mr. Kersey. There are 4 sections involved in the code with respect to vacancies, and the language that really is, it's the same in those sections, but it talks about, for example, in the first one, a governor shall appoint within 5 days thereafter a legally qualified person of the same political party with which the person holding the office immediately preceding the vacancy was affiliated. Current code's at the time the vacancy occurred. This would change it to at the time of a previous election for that office. And it does the same for each instance, with the idea that the appointment is not dependent on the party of the person was affiliated with when that person resigns from office or leaves office, but the last election for that office.
And there was a Supreme Court ruling on that issue?
I believe it was 2015 or 16, when the language was different. And then the legislature, so there was a conflict there. The legislature later revised the language as it currently is based on the court's ruling.
Thank you, and appreciate the opportunity to ask a question. So, as current code is, I came in 2017, that's how it's been, obviously, since the court's ruling. And your question is constitutionality, if I remember that correctly.
If the Secretary of State's office would have an opinion on constitutionality of this proposed amendment to the code.
The amendment is the length of time, is that right? It's to
No.
1 year?
No, this is a little bit.
The gentleman is seeking to amend another section of the same code section, another part of the same code section. So his amendment has nothing to do with the 1 year or 60 days or anything.
Mr. Chairman, could we provide a copy of the com sub to the witness so that
Someone
he
hand
could
him a
take a look
com
at it?
sub, and we're handing him a copy of the amendment if he can read it. Can someone hand Mr. Kersey a copy of the committee substitute?
Thank you.
I'd recommend looking at page 1, line 13.
So as I understand the amendment, it's essentially codifying what was decided in 2015, as I understood the description.
No, it is codifying a different policy than that of the Supreme Court that year and what was later codified by the legislature.
Right, yeah.
Yes.
It's going back to what the Supreme Court was deciding on, that said this perhaps may not be constitutional. Well, if that is the case, having not read that case, then our opinion would be we certainly want to follow Supreme Court precedent. Codifying something the Supreme Court's opined on seems to be contrary to the way that the law works.
So your opinion would be that this amendment would potentially be unconstitutional based on the Supreme Court's decision?
I certainly would defer to the committee counsel to make a legal opinion on that, but...
Thanks.
Gentleman from the 76, address Mr. Kersey.
And I apologize. I know this is a complex issue, and I want to be very clear. So my understanding is the Supreme Court did not make any constitutional finding. They made a finding based on the language as was in the code at the time. As far as really it was based on holding the office immediately preceding the vacancy. And so it was not a constitutional analysis. It was an analysis of the language at that time in the code. Just to be clear with respect to the gentleman's question. Does that make more sense in that context?
It does, and my answer would remain the same. If the court has ruled on something that says it's unconstitutional, certainly our office would have a concern with codifying something that's been found unconstitutional, but the opposite remains true. If it hasn't been ruled on that it's unconstitutional, then
So there doesn't appear to be any constitutional issue with the amendment if it was adopted?
I would, again, defer to committee counsel to provide guidance on whether it's constitutional, but it seems that we're just changing of when we have to look at the registration and the time it was effective, and then not the date the vacancy occurred and backing it up a number of days or years or whatever it may be.
Thank you. Thank you, Mr. Chairman.
Other questions of Mr. Kersey? Questions, Mr. Kersey? You might hang on, Mr. Kersey, but question to council?
Yes, or the sponsor, whenever the chair permits.
Does the gentleman yield?
Yes, sir.
Gentleman
Yes, sir.
from the 66th.
Sir, if your amendment's adopted, will have the effect of, say, it speaks of an office holder of a certain political affiliation at the time that they resign from a local board or a local office. Is that right? That's what it would affect?
No, it would affect every single office, from state officials to members of Congress and the Senate, to members of the legislature, to local elected officials, for example, prosecutor, surveyor. Judges are unaffiliated, so I don't think it would apply to them, but judges are listed in the first category.
All right. So with respect to the office holders that you just mentioned,
Yeah.
your amendment, if adopted, it would mandate that the governor would assign someone of the same political affiliation as the individual who vacated the office and compel the position to be filled. Is that right?
So he has to appoint right now. The only difference is he has to appoint from the party currently from which the person was affiliated at the time that person resigned from office. So it's a matter of the point in time at which the party is, that's applicable. My amendment would change that in each instance to not when they resigned, not when the vacancy occurred, but to when that person was last elected. And the gentleman from the 20th, we talked briefly about, what if somebody was appointed in the meantime, right? If there had been two appointments. But still, you'd go back to the last election. The last time the people had the opportunity to say whether they wanted a Democrat or a Republican in there.
So in summation, for my clarification, if someone was elected to an office as a Democrat,
Yes.
and then after becoming elected, decided to change their political affiliation to Republican,
Yes.
and then vacated or resigned from the office for whatever reason, or
Yes.
passed away, then the person that would have the authority to then assign their replacement would have to follow the party they were affiliated at the time that they were elected or assigned to office. Is that right?
At the time of the election.
At
Yes.
the time of the
At the
election.
time of the last election for that office.
So it's
So the Democrat in that instance, it'd be the Democrat. If it was a Republican and somebody was elected as a Republican, and then they decided, maybe it's not popular right now, but they decided to change their affiliation, then it would be the Republican that would have to be appointed from usually a list of 3 people that's given to the governor in those instances.
Okay, I'm not trying to get into the weeds here, but some of these people are assigned already. I guess
They're appointed, they're
Excuse
not
me,
assigned,
appointed.
yeah, yes.
Right, I was using that interchangeably. I got it. So basically, what your amendment seeks to do is keep the same party that the person elected was affiliated with. If they were to pass away, resign, or be removed, their predecessor, or excuse me, their successor would have to be of the same political party, regardless of what political party the person that left office was at the time that they left it. Is that right?
That's exactly right.
I got it. Now, I'm sorry. Thank you. And you clarified it very well. I appreciate the gentleman.
Thanks, sir.
Gentleman from the 88th.
Thank you, Mr. Chairman. Question to the sponsor of the amendment.
He yields.
Yes.
Thank you. An interesting amendment. I'm intrigued by it in a good way. I want to ask a specific application here because in being in one of these elected positions here, I've seen how occasionally things like a day's seniority might mean something, especially at the federal level. So we have a person who switches parties. There's another election, but they have not taken the oath of office for that second election. Okay, so now let's say it's December, right after the election. They step down. Who gets appointed, who gets to choose the appointment and from what party? Do you see where I'm going? Because
I do. I think there's an answer to that question.
I've seen in the past where people will do that in order to get 2-day seniority for committee assignments and stuff like that.
So I think someone would be appointed for the remainder of the period of time, and then the election, so for example, let's say it's November, person gets elected, but they're still serving until December. That's what you're saying, and they step down in the meantime. So I think the governor potentially could appoint somebody, let's say it was a state senator. They could appoint somebody, and it would last for the period of time until the election, the new person would come in. But if it was the same person, I think if they were elected as a Democrat in that last election, then it would be a Democrat. The appointment, I think it would be part of it might be short-term, but then it might be when the next person comes up, it would have to go back to the last election, if that makes any sense.
I think it does. I think it may actually suppress a little bit of that gamesmanship.
Yes.
Thank you.
Further questions? Seeing none, does the gentleman wish to close?
Yes, briefly, very briefly. I think this is just about fundamental fairness. And I hope the committee would
I asked for further questions. Excuse me, did you have a question?
if there's discussion, then absolutely, yeah.
He was answering questions that he yielded.
I thought he was finished.
We haven't had discussion.
You're right.
Okay. Discussion?
I have one short question for the gentleman from the Secretary of State's office, if it's okay, Mr. Chairman.
It's fine.
Thank you, Mr. Chairman.
Does this bill have anything to do with county clerks or circuit clerks?
The sub that I received actually excludes Section 7, which
would be the circuit
county
clerks.
clerk, circuit clerk, county commission.
And the amendment adds that back in?
Excuse me, circuit clerk is Section 6. Circuit clerk is also excluded.
Okay. That's all I've got.
Further questions of the witness?
Just appointment, not election.
Seeing none. Further questions of counsel? Okay, we're on the discussion phase. Yes, gentleman from the 88th?
86.
86.
Or either one.
Go ahead.
Thank you, Mr. Chairman. It's hard to separate yourself from politics in here, but my friend from the 76th, on principle, has a solid amendment, and I'll be supporting it.
Gentleman from the 88th.
Thank you, Mr. Chairman. I agree with the gentleman to my left from the 86th on the 88th. I think the amendment as proposed by the gentleman from the 76th is a sound amendment. It may not be self-apparent. I actually know a few Democrats, have some on my committee, actually, and have one in particular who might be listening at home that raised this type of issue at church one day. So, Elizabeth, if you're out there listening, this is your bill or amendment. I think this is a good amendment.
Further discussion? Gentleman from the 20th.
So I'll have to say I'm very happy with the way, I'm very happy this wasn't in law before, but I do support the change that the gentleman is making here.
Gentleman from the 53rd.
Thank you, Mr. Chairman. I support this amendment. I think it's a very, very good amendment. Gentleman from the 76th and I on controversial things often disagree, but I am joining him in support of this. One of the things we have to factor in, I think, is anytime we're making law of this sort is we can't just be thinking about the immediate. We have to be thinking about perhaps the next 100 years. I mean, this bill, for all we know, this language might not be amended possibly ever. Might be in the next 50 or 100 years. We don't know, but we're making legislation that is intended for the long term, for durability, and I think it's just the right thing to do. So I would just urge support.
Gentleman from the 13th.
Chairman, I too rise in support of this amendment. It makes sense. If you're elected one way, it should go back to that way. Let's go ahead and pass this amendment through and move on. Thank you.
Further discussion? Gentleman from the 100th.
I also support this amendment. This is reflective of what the people, both in their primary and in their general election, voted for, and that's what we should get back to, is what the people want and not what an individual decided to do at some point during his tenure.
Further discussion? Want to close? Thank you.
Thank you, Mr. Chairman. So I lived this in the General Counsel's office back when this happened in 2015. I lived the Supreme Court case. I thought it was incredibly unfair when that happened. And you know what? If it happened the other way, I wouldn't want it to happen that way. I believe that the people are the ones that should decide. But I will take a hint from the gentleman from the 13th, and we'll move on. And I appreciate the support of my amendment.
All those in favor of the gentleman's amendment signify by saying aye. Aye. Opposed, no. The amendment passes. Further amendments? Seeing none, I look to the gentleman from the 16th for a motion.
Thank you, Mr. Chair. I move the committee substitute as amended for House Bill 5373, reported to the floor, recommendation that do pass.
For the gentleman's motion, is there discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed, no. Bill passed. Next bill up is 5445. I believe council's in waiting. Committee will be at ease for a minute. Good job. That was a good amendment. Will. I swear. Okay. Who's got 5617?
Yeah, we haven't distributed it yet.
Okay. How about 5623? We're looking for an attorney. 5623. No, 5623. There is. Council was present. You're fine, sir, you're fine. Committee will come to order. Council, when you get your breath, you may proceed.
Thank you, Mr. Chairman. The bill before the committee is House Bill 5445. It is revising the statute to reduce minimum age for a cadet for the West Virginia State Police from the age of 21 to the age of 18. It amends Chapter 15, Article 2, Section 7. The short title pretty much describes the bill. It just strikes the word or the number 21 in the code. This is for original appointment of West Virginia State Police cadet. The minimum age now is 21. This bill would reduce that to the age of 18.
Thank you. Questions of council? Yes, the gentleman from the 65th.
Thank you, Mr. Chairman. Council, are you able to be an officer at age 18 in all other instances besides state police?
The cities and the counties both have minimum age of 18. The DNR technically and by code which is the other statewide law enforcement agency, is 18, but internally they actually have some other qualification requirements like a college degree. So I think in reality you can't be a DNR officer at 18, but their code also says 18. So this would normalize it with the other cities and counties and DNR.
Do you know, council, if you can run for sheriff at 18?
I believe you can, and that is a constitutional position, so that doesn't require you to be a certified law enforcement officer to be a candidate for sheriff.
Right. All right, thank you, council.
Yes,
Thank you, Mr. Chairman.
Further questions of council? Does anyone wish to call a witness? Are there amendments? We have one amendment from the gentleman from the here he is, 94th. Do you wish to?
Yes, I wish to proceed.
Wish to proceed?
Yes.
Okay, the gentleman's amendment is on page 1, lines 8 and 9, and it would state as follows: delete no more than 39 years of age on page 1, lines 8 and 9. Does the gentleman wish to explain his amendment?
Yes, briefly. I certainly support the the initial proposal, but I don't think it goes far enough. If you look at the law, other than in my amendment, it says that whoever is appointed to serve in that agency has to be of sound constitution, pass any mental or physical examination, or meet other requirements. I believe the age cutoff at age 39 is just flat-out age discrimination. I don't think that's necessary, and I think the bill would be better to take that out.
Questions of council as regard to the effect of the amendment? Questions of council? Yes, gentleman from the second.
At the appropriate time, I'd like to hear from somebody from the state police.
Questions of council? Gentleman's asked leave of committee to call state police. Sir, if you'll take that, introduce yourself.
I'm Major Jim Mitchell, Chief of Staff for the State Police.
Would you raise your hand, sir?
Yes, sir.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Thank you. Gentleman may proceed.
Thank you, Mr. Chairman, and thank you, Mr. Mitchell, Major Mitchell, for being here. You've heard the amendment that was just put forth. Could you give us an idea of why 39 is picked and what the effect would be?
Yes, sir. I think our current superintendent, Colonel Chambers, before he retired, actually 7 or 8 years ago, actually had that age limit instituted. And the purpose behind that, I think, was twofold. One was it followed the federal guidelines of law enforcement as far as cutoff age, and also the second one was it would enable us to have a trooper for a potential 20 years, a full service, a full retirement, because most people will retire from the military after 20 years, which would put them around this age, and which would allow us to hire a retired veteran, but still be able to maintain a service of hopefully 20 years in the agency.
If somebody were a Maryland State policeman and they were 39, and they came to West Virginia and applied, would that be a consideration, or you would say that it's a little bit too late for you?
Well, they would have to be that age upon the beginning of the training. They could be older than that upon graduation, but at the date of training starting, they would have to be within those age limits.
Okay. Thank you.
Yes, sir.
Further questions, gentlemen from the 88th?
Thank you, Mr. Chairman. This is an interesting amendment here. We have a similar bill, 5122, dealing with sheriffs and local law enforcement that's over in the Senate right now. We did not address state police in particular, but one of the conversations that we had with regards to removing the age caps for deputy sheriffs, et cetera, was there was some question about age discrimination and things like that. Do you have counsel here or others that could address that? Is this potentially leaving this here still an issue from an age discrimination perspective?
I can't testify to the legality of that in context of your question. I could say that that is our preference as an agency to leave it at 39, but certainly if that were to become a legal issue, we certainly comply.
Are there other criteria that you would be able to evaluate? For instance, if I were to apply, and I'm not 39 anymore, it's been quite a while, that you would be able to weed me out of the pack and say, you know, you're not physically fit or something like that. So you wouldn't have somebody that's going to be 68 in a month or two trying to become a new state police officer.
On those extra criteria, you're assuming that that would be based upon if we didn't have an age cap at 39.
Correct.
Okay. If we did not, would there be other things we would consider? Well, they would go through the regular hiring procedures, which would include a written examination, several levels of psychological examination, as well as physical agility. And that might be one of the biggest ones, because I'm not 39 anymore either. And it's a difference as you get older. So we would have to evaluate all of those things to see, considering if the age limit was not in place. There would be other factors, yes.
Thank you. Thank you, Mr. Chairman.
Further questions of the witness? Gentleman from the 100th?
At this point, if we removed this language, you would still have the discretion of looking at the other aspects, sound constitution and a good moral character. Based on that, you can make a judgment as to whether or not you want to accept an applicant if you do not believe that he's going to be able to make it not only through the training but through a sufficient period of time of service to make it worth the training costs that you would be expending. Correct?
Yes, we would still have that discretion. And you mentioned training cost. We invest about $192,000 into a cadet within their first year. So yes, but we would still have that discretion.
So if we remove this language, it actually just allows you potentially to bring on applicants that you may actually want to bring in that are 40 or 41, because a lot of military members don't join and retire right at, I mean, they don't start at 19 a lot of times. They may come in at 20, 21, 22 years old. So you may actually be able to expand the applicant pool that you would have, that you may actually want to bring in, particularly given the shortages we see not only within state police, but within law enforcement in general.
If the age limit was removed, it would make the pool larger, yes, sir.
Okay. I understand, but I mean, it would actually give you that discretion to potentially go after those people that you would want to bring in,
Yes,
but
sir.
you're currently restricted from doing so.
Yes, sir.
Okay. Very good. Thank you, Mr. Chairman.
You're welcome.
Yes, further question? Delegate from the 8th.
Yeah, Major, thank you for your service.
Yes.
When did you graduate from the academy?
I went through twice.
Okay.
I went through the basic class as a city police officer.
Yes, sir.
Graduated in the 90s. I think it was 91.
Okay.
92, and then I came back through again in the full academy for the state police, and graduated in 2000.
Well, thank you for that. How many of your graduating class are still on the road?
Of my class?
Yes, from the State Police Academy.
Oh, for State Police Academy, I would say probably 50%.
50% are still on the road?
Yes.
Okay.
In
Are they
some
in
capacity.
administrative positions or still
Yes.
road troops?
A lot of us are in leadership positions now.
So would you say the most of you are in leadership?
Yes, of some capacity, from sergeant, detachment commander, or above, most of us,
Thank you.
yes.
Thank you, sir.
Further questions? Seeing none, are there amendments to the amendment? Seeing none, discussion. Delegate from the 8th.
Thank you. Major, thank you for being here. I think this is a slippery slope for us. I understand the gentleman's questions from the 100th. I understand those questions, but I think we're on dangerous footing if we remove this upper cap of 39. I'd love to be a police officer still, but I'm in no condition to do that. My mind tells me I can, my body says you can't. And so I think we need to tread on this very lightly. We need to the request was to remove that lower limit to 18. I think this committee is more than willing to do that. I would caution the committee on removing the upper cap. Thank you,
Further
Mr. Chairman.
discussion? Delegate from the 53rd.
Thank you, Mr. Chairman. I would urge support of the gentleman's amendment. What we're talking about here is, for example, somebody who could be 41 years old or 40 years old who meets or exceeds all of the other requirements of somebody who's 38 or 39 years old. I mean, I think that what we're talking about here is somewhat of an arbitrary distinction between the two. I mean, you could have a 40-year-old who meets all of the requirements and exceeds all of the requirements, who's similarly situated to somebody who's 38 years old, and the two candidates meet all of the same requirements. I think it's an arbitrary distinction. I think that the requirements that these individuals have to meet, I mean, we're not talking about a situation in which individuals aren't meeting the requirements. To get through the process, you have to meet all of the other requirements. So I think this is a good amendment. I think it makes common sense. I think an age of 39 is arbitrary, so I would urge adoption of the amendment.
Further discussion? Delegate from 100.
I would support the amendment, and the reason I would support the amendment is that we provide our state agencies with discretion in many cases so that they can make the types of decisions that are going to be in the best interests not only of the government but of the people. We have a incredible deficit in terms of law enforcement within the state, and to include our state police. And I think that we need to do whatever we can to try and provide additional means to get personnel who can fulfill some of the law enforcement responsibilities that we are deficit on right now. So I think it's something that we should try and support and get more folks out there to protect our citizens. So I would support the amendment.
Further discussion? Delegate from the 69th.
Thank you, Mr. Chairman. Well, I can speak from experience, having 27 years police experience. We had a cadet program in Washington, D.C. that brought in people 18 years old and older, and gradually they worked their way up to old enough to go through the police academy, and then after a while of that program, they began to take cadets and swear them in almost the first day if they met the qualifications as a police officer and send them to the academy. So they did start. Now, the problem was maturity as far as their mental capacity and their overall experience. Some were young and foolish, some were young and smart. And I'm sure that our state police would take time to test these people, do the background test, and that was the biggest thing in D.C. They really got behind on the background test. They were hiring people, and I would have cadets that come, or policemen come out of the academy and come work for me, and they would be bragging about how many guys in their class had got arrested while they were in school because the background check revealed they were wanted somewhere, or if the crime had come to, they had committed, and how many got walked out of their class in handcuffs. So I'm in favor of this, but I'm sure our state police will do thorough background investigations before they hire anybody and give them a gun and a badge. Thank you.
Discussion. Seeing none, the question for us is the amendment offered by the delegate of 94th. All in favor say aye. Aye. All opposed nay. No. Noes do have it. Other division is called. If you're in favor of it, raise your right hand or hand. You got it? You're against it? We were louder. The yeas do have it. The amendment is adopted. Are there further amendments? And Mr. Chair.
Further amendments? Further amendments? Seeing none, I look to the chair, or look to the gentleman from the 16th for a motion.
Yes, Mr. Chair. I move that committee said no. The bill, House Bill introduced, as amended, House Bill 5445 reported before recommendation that do pass.
Heard the gentleman's motion. Is there discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Ladies and gentlemen, we're going to stop there, listen to the floor announcements. We'll probably be back up here right after the floor session and complete this, so please listen to the announcements.